Kim, I have a quick request. Anvesha is waiting in the attendees list. Can you make her the panelist?
Yeah, Kim, can you add Anwesa to the panelist, please? Do you have her email address?
I'm looking
She's in,
for her.
she's in the attendees right now.
Oh, there she is. See her?
Yeah, she's here. Thank you.
Good evening and good morning, everyone.
Oh, damn.
All right, we got her.
Okay.
And hello, everybody else.
Hi, Anwesa. How are
Hi,
you?
Professor Brand. Hi, Raj.
Hi, how are you?
I'm good. I'm good.
Great.
Okay, so I think we'll begin in 2 minutes.
I'll also acknowledge the presence of our director, sir, Professor Avian Narasimha Rao. A very, very good evening, sir. And thank you for joining us.
Good evening and good morning to our friends in US. Good
Hello,
evening.
Professor Rao.
Yes. Good morning. Hope everybody is safe and doing good.
Doing well, staying healthy.
Yes, so far so good.
Mr. Raj, good evening.
Good evening. How are you?
Good.
I think it's sharp 9 o'clock now. So
We have reached our appointed time,
9:30, yeah.
so
Hello.
we will begin. Welcome to all those who have logged on. My name is Ronald Brand. I am a professor of law at the University of Pittsburgh School of Law, where I am also director of our Center for International Legal Education, CILE. This webinar is jointly sponsored by Pitt's Center for International Legal Education and ICFI University Law School in Hyderabad. It celebrates the completion of an MOU and the beginning of a new partnership between our two law schools. I want to thank all of those at both schools who have made it possible, and especially Rishabh Soni, who is an LLM graduate of the University of Pittsburgh School of Law and is now a faculty research associate at ICFI Foundation for Higher Education, Hyderabad, and the person most responsible for our partnership. This webinar is also the first in a series in which CILE at Pitt Law will highlight relationships with law faculties around the world. We invite you to watch for the invitations that will include the date and time of the future programs. We realize that the work of ICFI Law School has resulted in a significant number of attendees from Hyderabad and throughout India for this program. We are happy about that. We invite you, as well as those from around the world, to consider joining us at Pitt Law for our LLM program, a program that we think is very special. I think Rishabh might agree with that. Please check it out on our website at law.pitt.edu/LLM. That's law.pitt.edu/LLM. The webinar will consist of two presentations of about 40 minutes each, followed by a question and answer session. While our topic is international arbitration in general, we will focus on issues related to drafting the arbitration clause. We will be taking questions on the Zoom chat function during the presentations, and will then have a moderator who has collected questions, use them for a directed question and answer session after the presentations. So please use the chat function to send your questions during the program prior to the Q&A time. Two additional administrative matters before I turn things over to Rishabh. First, this webinar is being both broadcast live on YouTube because the response was greater than we could handle on Zoom, and is being recorded. It will be available on the CILE and ICFI YouTube pages for future viewing, so please tell your colleagues. Second, for those attending on Zoom and wanting to electronically receive a certificate of attendance, there will be a poll on the Zoom system at which you can request a certificate and provide the spelling of your name as you wish to have it on the certificate. Please then provide your email address so that we may send the PDF of that certificate to you. Finally, I want to thank those who behind the scenes who have made this webinar possible. I will let Rishabh acknowledge those at ICFI Hyderabad. At Pitt Law, those persons include Emily Schlauk, Deborah Hilton, and Kim Getz in particular. Once again, thank you for joining us. Good morning in the US, good afternoon in Europe and Africa, good evening in Asia. I now turn matters over to our partner at ICFI University Law School, Hyderabad, Rishabh Soni.
Thank you. Thank you so much, Professor, for such a warm introduction. It's our privilege to have you on board with us. Very good evening to all the attendees from India, and a very good morning to my friends and individuals attending the session from the United States. Welcome all the participants to the webinar on arbitration in India and United States, focusing on drafting the arbitration clause. It's our privilege to host both the law schools through the virtual world post our MOU collaboration. The ICFI Foundation for Higher Education is a deemed university established under Section 3 of the UGC Act 1956. It has evolved a comprehensive student-centered learning approach consisting of several stages designed to add significant value to the learner's understanding in an integrated manner, covering relevant knowledge, practical skills, and positive attitude. The Faculty of Law, commonly known as ICFI Law School, is a constituent unit of the ICFI Foundation for Higher Education, located in the lush green environment in the vicinity of the historical city of Hyderabad, India. ICFI Law School comes to the top-ranking private institutes in India. The ICFI Law School was recently ranked third in India among top leading law schools of super excellence by CSR, GHRDC. ICFI Law School Hyderabad was also ranked third among top law schools by India Today, following which the ICFI Law School offers undergraduate 5 years BA LLB and BBA LLB honors program, postgraduate LLM in 3 different genres, PhD in law, and 8 different certification courses. The law school also has Center for Excellence in Environmental Law, Corporate and Commercial Law, Cyber Law, Criminal Law, and IPR. 2 new centers are under the process of getting the authentication, and the centers are Center for Excellence in Global Studies and Center for Excellence in ADR. And with this, I will also like to thank University of Pittsburgh School of Law, specifically Center for International Legal Education, for agreeing to this memorandum of understanding between both the universities. It's been a privilege of serving as the connecting cord between both the universities, and it was a wonderful experience overall. I'm looking forward to the future prospects and the future opportunities which both the law schools can develop together. Finally, now without taking much of your time, I'll introduce the speakers for today. Our speaker from the United States, Professor Ronald Brand, is the Chancellor Mark A. Nordenberg Professor of Law and Director of the Center for International Legal Education at the University of Pittsburgh School of Law. For over a decade, he has worked with the US Department of Commerce to develop Middle East Law School curriculum in international commercial law and arbitration by training students and faculty from schools throughout the Middle East and North Africa. Thank you again, Professor, for joining us. Our speaker from India, Mr. Raj Panchmatia, is a partner in the Dispute Resolution Practice Group of Khaitan & Co. and is based out of Mumbai office. Raj has a rich experience in the field of dispute resolution and commercial litigation, both at the domestic and the international forum. He has advised clients on a wide variety of claims under the international arbitration law, Singapore International Arbitration Center, London Court of International Arbitration, International Chamber of Commerce, UniCentral, and Hong Kong International Arbitration Center. He has an extensive experience in dealing with disputes under all forms of contracts and agreements. Raj is also appointed on the SIAC panel of arbitrators and HKIAC list of arbitrators. Moving further, I would first like to invite Professor Ronald Brand to share his insights on the basics of the drafting and arbitration agreement, following which we will hear Mr. Raj Panchmatia on the international arbitration in India and the arbitration agreement. Again, thank you so much everyone for joining, and I hope we will have a very fruitful session. Thank you so much.
Thank you, Rishabh. Deb, I need to share my screen and it has been disabled. So if you could enable that for me, I will pull up my PowerPoint so that everyone will be able to see that. Okay, good. Okay, Can someone confirm? Is the PowerPoint
We can
slide
check.
showing? All right, good. Again, welcome everyone to the program. As I mentioned in the introduction, this is a program on international commercial arbitration, but we're going to focus on drafting the international commercial arbitration agreement, the arbitration clause in the commercial contract. I will cover a set of points, and I'm the academic on the program. Raj is the practitioner. We're both going to try to deal with theory and practice, but I'm going to leave the details of drafting, I think, to Raj. I'm going to try to set the context for that. I realize that many of you who are listening are well versed in arbitration, but I'm going to start with the basics. I'm going to define arbitration so that we can think about what it is we're talking about. And as I go through each of these steps, I will try to deal with how each of the steps relates to the drafting of the arbitration clause. I will second focus on the concept of consent, because without consent, there is no arbitration. Arbitration is based upon the agreement of the parties. If we do not have an agreement of the parties, we do not have arbitration. That makes it different from other types of dispute resolution, particularly litigation. I want to spend a little bit of time on advantages and disadvantages of arbitration, because those play into drafting the arbitration clause as well. I will then review briefly the basic legal instruments for international arbitration. I will say a few words about the difference between institutional arbitration and ad hoc arbitration. I will say some things about the text of the arbitration agreement, but leave much of that for Raj. And then I will focus on applicable law in arbitration, because in order to draft a good arbitration clause, you really need to know what law governs what it is you are doing when you're drafting that clause. So let's begin with the first basic concept, defining arbitration. And here I borrow from Gary Bourne's list of factors for the definition of arbitration. And these are the factors that distinguish arbitration from other types of dispute resolution. Arbitration is consensual. It is a means for resolving disputes, but it is based entirely upon the consent of the parties. Again, without consent, there is not arbitration. It is non-governmental. The decision maker is non-governmental. That clearly sets it apart from litigation, from going to the courts. Parties may choose the decision maker. This ties together consent and the non-governmental aspect, but it does mean that the parties can choose experts in the field in which the dispute has arisen. They can choose those who know something about the types of issues that are going to be important to the matter in dispute. Arbitration results in a final and binding decision. Okay, this differentiates it from mediation, conciliation, from consensual means of dispute resolution. And finally, it is an adjudicatory proceeding, which again distinguishes it from mediation. It's final and binding in that once you have the decision, you are finished with the caveat that there are some very limited opportunities to challenge the award, but there is no opportunity for an appeal. So it's unlike litigation in that sense. We're going to talk about drafting an arbitration clause, and I think it's useful to think about the types of forum selection clauses you can have. And usually the choice that is made in international commercial contracts is a choice between a choice of court clause and an arbitration agreement. Obviously, an arbitration agreement gives you an opportunity to have a more neutral forum than going to party A's national courts or party B's national courts. Second basic concept is that concept of consent. Arbitration does not occur without the consent of all of the parties involved to the proceedings. And that's where the arbitration agreement is important, because you should draft the arbitration agreement to express that consent clearly. The other aspect of the consent factor is one that distinguishes arbitration from litigation. Often in litigation, a case will involve multiple parties. Often in contracts, you have only two parties, but you may have other parties that have been involved in the facts that lead up to the dispute. Arbitration can make it more difficult to bring in multiple parties outside the contract to the dispute, and that's important, and it is an element of consent. The fundamental document that governs international commercial arbitration is the New York Convention, the United Nations Convention on the Recognition and Enforcement of Foreign Arbitral Awards. It was completed in 1958. It now has 164 parties. That means it is truly a global convention, one of the most successful in the area of international trade and certainly in dispute settlement. Even though the title is the Convention on the Recognition and Enforcement of Foreign Arbitral Awards, it deals as well with arbitration agreements, the recognition and enforcement of the agreement in Article 2. The other articles deal with awards. Article 2 deals with the agreement. It begins in paragraph 1 stating that each contracting state shall recognize an agreement in writing under which the parties undertake to submit their differences to arbitration. Paragraph 2 gives us some formal requirements on the agreement in writing, and I will come back to that. But paragraph 3 then allows a party to go to court and have that court refer the parties to arbitration. In other words, enforce the arbitration award. So the consent must be there. There is a formal method by which you must express that consent, and we'll come back to that. But when that happens, that agreement is enforceable in the courts in 164 legal systems of the world, including India, which became a party in 1960, and the United States, which became a party in 1970. Third basic concept. Arbitration is championed on the basis of a number of advantages, both real and perceived. And when you're drafting the choice of forum clause and trying to decide between choice of court and arbitration, there are a number of issues you want to consider, including those that have been expressed as advantages of arbitration. One of the main advantages is neutrality. Oftentimes in an international commercial contract, the last provisions that are considered are choice of forum and choice of law. The parties have finished the economic agreement. They want the legal part and want to get on with their business relationship. But neither wants to go to the courts of the other party. Arbitration provides for neutrality and is often chosen for that reason. It provides for centralized dispute resolution. All disputes related to a commercial arrangement, a commercial relationship, can be taken to the same forum. And perhaps the most commonly expressed reason among lawyers who draft international commercial contracts for including arbitration agreements is enforceability. As I've mentioned, the New York Convention is the law in 164 jurisdictions around the globe. That we have no comparable treaty on litigation. There is the 2005 Hague Convention on Choice of Court Agreements. It has not yet been ratified widely enough to bring it even close to the New York Convention on that plane. One of the advantages is that you can select your own decision makers, the arbitrators, and you can select them precisely for competence and expertise in the field of the dispute. Finality of decisions is an advantage. Now, we need to acknowledge that every advantage can carry with it disadvantages. Obviously, if you believe the decision was wrong, finality and no opportunity for appeal is a disadvantage. But in terms of Getting on with business relationships, finality clearly is an advantage. Party autonomy and procedural flexibility. In arbitration, not only can you choose your own substantive law, you can choose your own procedural law, and that has its advantages. Arbitration early on was considered advantageous because it was faster and costs less. Now you have to think about that when you're drafting the clause, because that's not always the case. Arbitration can include expenses that don't occur in litigation, and there can be delay. Now, what has happened most recently is that just about every arbitral institution has amended its rules to provide very clear time limits on the tribunal. And so the speed element has come back to arbitration. Confidentiality is perhaps, after enforceability of awards, the second most often stated reason for arbitration. Business parties don't like to have their laundry hung out in public. And when you're in courts, the matter of the record is public. In arbitration, it is private, it is confidential unless the parties decide otherwise. And finally, in arbitration, you can have states and state entities as parties. In courts, the states will always have the opportunity to raise the defense of sovereign immunity. If they have consented to arbitration, there you've already gotten past that hurdle, and you won't have to litigate those kinds of issues. As I said, every advantage carries a disadvantage. Obviously, the consent requirement means that you have greater difficulty in joining non-consenting parties. The lack of an appeal can be a disadvantage if you think the decision was wrong. Confidentiality can, on the flip side, create problems because if you're choosing an arbitrator and the awards that arbitrator has rendered in the past are all confidential, you don't know if that arbitrator has rendered a decision that is contrary to your party's position. The same holds for independence of arbitrators. With courts, you have a track record. You can see how the judge has decided in the past. And finally, preliminary relief. In today's world, one of the most important aspects of any dispute resolution in international disputes is making sure that if you get a judgment or an award, it will be enforceable. There will be assets against which you can collect. Arbitration creates somewhat greater difficulty in obtaining preliminary relief, but more and more that difficulty is being diminished. Fourth basic concept I mentioned was the importance of a basic set of international arbitration instruments. Those instruments are fundamental to understanding international arbitration. The most important is at the treaty level. The New York Convention, we've already mentioned it, with 164 parties. In the Western Hemisphere, we have also the Inter-American Convention on International Commercial Arbitration, the Panama Convention, that may apply if the parties are both from states that are contracting states to that convention. The treaty sets out the basic rules. Second, the lex arbitri. Now, the lex arbitri, or what is sometimes called the curial law, is the law of arbitration. It's the law governing the arbitration proceedings. In the United States, that is the Federal Arbitration Act, but it can also be state law. In India, the Arbitration and Conciliation Act of 1996 was amended in 2019. In many countries, it is some form of the UNCITRAL model law. The UNCITRAL model law has become the basic text for working forward to establish modern arbitration statutes. I mentioned the United States, which has a federal system. In the United States, you may have both federal law and state law applying. In the states, many of the states have followed the UNCITRAL model law. Many have followed the Uniform Revised Arbitration Act, which was created by the Uniform Law Commissioners. Federal law will preempt state law where they conflict. Where they don't conflict, state law may govern the matter. Keep in mind that the lex arbitri is an important element in your arbitration clause. A good arbitration clause will list the seat of arbitration or the place of arbitration. Now, that is not a statement that tells you where the hotel is or the conference room is in which the arbitration will take place. It is a choice of law clause. It chooses the lex arbitri. If you have the seat of arbitration shall be New York, you have the Federal Arbitration Act and the New York statute. If you have the place of arbitration shall be Hyderabad, you have the Arbitration and Conciliation Act of India. Okay, so that is not very important to understand that is not a choice of venue or location of the arbitration. It is a choice of law clause. Third type of legal instruments that are important here are institutional rules. If you choose institutional arbitration, that brings with it a set of rules. You can have the American Arbitration Association's International Center for Dispute Resolution, the International Chamber of Commerce, the London Court of International Arbitration. There are, in every country, there is one or more arbitration centers. Many of those centers have now based their own rules on the UNCITRAL arbitration rules, so that there is a fair amount of uniformity across the globe on that. But this is the way in which you have a right to choose the procedural rules that govern the arbitration. And basic contract law. Remember that arbitration agreements are in just that. They are agreements. And agreements are governed by contract law. You don't have an agreement unless you have followed the rules of contract formation. That may be domestic law. It may be an international treaty. If the parties are both in states that are parties to the UN Sales Convention, the CISG, then the law of formation of the contract, including the arbitration agreement, may well be the CISG. Fifth basic concept, that choice between ad hoc and institutional arbitration. This is an important one. Institutional arbitration gives you a set of rules that comes with it. Probably most importantly, it gives you a set of default procedures. With ad hoc arbitration, if the other party refuses to show up, you've got some difficulty. With institutional arbitration, you have a set of rules, you have time limits, you have procedures by which the dispute can move forward to a binding and final decision. Now, when you choose an institution and put that clause in the contract for your client, you should never do that without going to the end of the arbitration rules and checking their fees. And you may want to compare them with the fees of other arbitral institutions. Because if it turns out that you do go to a dispute and your client then says, well, wait a minute, why do I have to pay such a big fee to start the arbitration? You need to be able to explain that and let them know that although it may be large, it's reasonable given the circumstances. Other issues that you want to look for in institutional rules, preliminary and emergency relief, the ability to get that relief from the tribunal itself, rules on taking of evidence, whether the institution has them or you want to pull them in from elsewhere, administrative assistance, whether you can join third parties to the arbitration, and call it whether you can consolidate claims, bring in multiple claims between the same two parties. Those last two you usually can do in courts. You want to make sure that the procedures allow them in arbitration if you think they might be necessary. Sixth basic concept is the text of the arbitration agreement. Of course, that's key to everything. What should it include? Obviously, it should include consent. If you want to have it enforceable under the New York Convention, it should meet the formality requirements. It should be in writing, signed by the parties. It should have a clear scope. Normally, you want broad scopes so all of your disputes are settled in one place. You should have a choice of institutional rules if that's what you want, if you don't want to go with ad hoc arbitration. Choice of the seat, the place of arbitration. Remember again, that is a choice of law clause. It brings with it the law, the arbitration law, the procedural law of that jurisdiction. choice of the number, and the method of selection of arbitrators. If you choose institutional rules, that will be a part of those rules. You won't have to set it out separately. Choice of the language of arbitration. Obviously, that's important if the two parties each deal in a different language. Choice of the substantive law governing the parties' relationship. And recent decisions in particular have told us that it is important to show the choice of the law governing the arbitration agreement itself, which may in fact be different than a choice of the substantive law. Allocation of costs, the interest and currency of the award. This is something that varies dramatically in various countries, how much interest can be awarded, how it can be dealt with, and when it can begin. You want to make that clear. Discovery rules. You may want to bring in rules for gathering of evidence so that it is clear if such rules are not a part of the institutional rules you've chosen. If you want fast track or preliminary procedures, if you want multi-tier dispute resolution, if you want to begin with negotiation, move to mediation, then to arbitration, you want to think about that and the advantages and disadvantages. And again, if you have a state or an entity of a state involved, sovereign immunity, confidentiality. Each set of arbitration rules is a little bit different on the question of confidentiality. You may want to write that into your agreement. Waiver of annulment. Some states will allow that, some states will not. You need to know if it's available. And obviously, you get to the finality much sooner if you can waive annulment. If you want the ability to bring in multiple parties. And finally, provisions for jurisdiction and service for purposes of recognition and enforcement. You obviously don't need a consent to jurisdiction, that's in the arbitration clause, for arbitration or for service of process or notice, but you need to think ahead about enforcement of an award, and for that you may want to add a provision that provides consent to jurisdiction and to service of process in the country in which it may be most necessary to recognize and enforce that award. I move now to applicable law, which I've said is, I believe, very important here. And unless you understand the law governing what you're drafting, you really can't draft properly. So let's deal a bit with that. And in doing so, it's also crucial to understand not only what law gets applied, but who decides the issues to which each law applies. Now, this brings us to two basic doctrines of arbitration. The first is the doctrine of separability or severability, the idea that the arbitration clause, even if buried in the commercial contract, is separable for purposes of determining validity, existence from the entire contract. You may have a valid arbitration agreement, but an invalid contract. You may have a valid contract, but an invalid arbitration agreement. And you may and are likely to have a different law applied to each of those questions. The other doctrine is competence-competence. Competence-competence is the doctrine that says that the arbitral tribunal has the jurisdiction, has the competence to determine its own jurisdiction, its own competence, to decide whether or not it really has the right to hear the case. Now, there are 5 basic issues in applying these doctrines to drafting an arbitration agreement. One is the issue of consent, the existence of the agreement. The second is the formal validity of the agreement. The third is the substantive validity of the agreement. The fourth is the scope of the agreement. And the fifth is the exclusivity of that agreement. So let's work through those, but as we do so, we need to ask 2 questions regarding each basic issue. First, what law governs the issue? And second, who decides the issue? I want to begin with the who question because you can start out thinking, well, it's easy. There's only one place we go on all of this. And if we look at the UNCITRAL model law and the UNCITRAL rules, it looks that way. It says the arbitral tribunal may rule on its own jurisdiction, including existence or validity of the arbitration agreement. And the UNCITRAL arbitration rules say exactly the same thing. The arbitral tribunal shall have the power to rule on its own jurisdiction, including any objections with respect to the existence or validity of the arbitration agreement. Now, let's think about that and apply it first to that first important issue, consent. And we have to ask what law governs, who determines whether an agreement to arbitrate exists. Well, the New York Convention, the UNCITRAL model law, the UNCITRAL arbitration rules, that package of arbitration law that you may pull into your contract, none of those has rules on contract formation. The question of consent is a question of contract formation. If we look at the New York Convention, we start with the fact that it is in title and in Article 1, a convention that applies to recognition and enforcement of arbitral awards. But then we go to Article 2 and see that it also applies to agreements. But the agreement must be concerning a subject matter capable of settlement by arbitration. That's a limitation. Now, that's an interesting limitation because it effectively gives every contracting state the opportunity to unilaterally amend its own obligations by saying certain matters are not arbitrable. Same thing is true about validity. But note in Article 2, Paragraph 3, the court shall refer the parties to arbitration unless it finds that the said agreement is null and void, inoperative, or incapable of being performed. So the arbitration law we do have does tell us there's a role for courts, even if it is the UNCITRAL model law or some form of it that says the tribunal can rule on it, the existence of the arbitration agreement. And even the model law itself gives a role to the courts. A court shall refer the parties to arbitration unless it finds that the agreement is null and void, inoperative, or incapable of being performed. Okay. Now, under Paragraph 2, the proceedings may continue while the court decision is pending, and so you can have parallel proceedings in court and in arbitration on some of these issues. Let me just note a couple of cases that are important on this. The premium NAFTA case in the UK in 2007, you'll see Lord Hope of Craighead said that if there was no contract to go to arbitration at all, an arbitrator's award can have no validity. That's a matter of competence. If there's no contract, you have no competence. But who decides whether you have a contract? Okay, and this suggests then that the court would decide that. So where the arbitration agreement is set out in the same document as the main contract, the issue whether there was an agreement at all may indeed affect all parts of the contract. That's the severability question. In the United States, Buckeye check cashing stated very clearly, it is for the courts to decide whether the alleged obligor ever signed the contract, whether the signing was with authority to commit the alleged principle, and whether the signer lacked the mental capacity to assent. So stating that those are matters for the court. Now, just in June of this year, the US Supreme Court again addressed the question of consent, suggested that domestic equitable estoppel doctrines can be used to bring in parties who have not signed the contract themselves. Now, you want to be careful how far you take that decision because it has been remanded for further consideration in the lower courts. And I believe that in those contracts, there's a prime contract, a subcontract, there's a relationship by which you can find that there was consent clearly expressed in writing by the party that is being brought into arbitration. But the case itself now is authority for the idea that you can bring someone in who may not have signed the arbitration agreement itself. When an arbitration agreement exists, we saw Article 2.3 of the New York Convention, a court shall refer the parties to arbitration. The Federal Arbitration Act really is seen as being stronger than that and allows the court not just to refer the parties to arbitration, but to compel them to arbitrate. Second issue is formal validity. What law governs and who determines? This, I think, is much easier. The New York Convention makes it clear. You must have an agreement in writing signed by the parties. Now, that's 1958 drafting, keep in mind. And so with the development of the internet, email, electronic transmissions, the handwriting on paper documents is not always what you have. Now, the UNCTAD model law in 2006 provided for an optional amendment that would say that in writing is satisfied if the content is recorded in any form that has been included orally by contact or other means. So it's recorded in any form. Some way that you can pull it back up for purposes of evidence. There is a second option in the model law that doesn't do that because the New York Convention has not been amended, and your local law cannot serve to amend the New York Convention. But the tendency is to respect, for example, email agreements. We now have concepts of electronic signature. You should be careful, however. If you want to be absolutely certain, have it in writing, signed by the parties, very clearly taken care of. Substantive validity. What law governs? Who decides? Here we go back to the New York Convention, Article 2. The question of arbitrability in Article 2, Paragraph 1, and the question of substantive validity in Paragraph 3. Now, the New York Convention does not tell us what law governs that. So you have to refer to the rules of private international law in the forum in which you are dealing with a dispute to determine whose law determines arbitrability, because the laws of various countries are very different on that, and whose law determines substantive validity. So keep in mind that Article 2 of the New York Convention contains no provision telling us what law governs the question of substantive validity. That is left to the rules of private international law. Now, under Article 5, when we get to recognition enforcement of the award, the convention does something different. It says, as to the arbitrability question, that is determined by the law of the country in which recognition enforcement is sought. There is a specific choice of law or applicable law rule there, but not for the Article 2 question on the agreement. Now, in the United States, most of the federal circuit courts have decided that one of the important issues these days, class arbitration, is a gateway issue, and that the courts decide that, not the arbitrators. So we get this distinction, even though the UNCTAD model law, the UNCTAD rules, and the arbitration rules you select may say that the tribunal can decide, well, courts may say, well, not so fast, this is for us. Scope, what law governs, who determines? Scope is a matter of interpretation of the clause itself. You want to be sure that you deal with what is covered. Does it cover tort claims, statutory claims, multiple contracts, multiple parties? Exclusivity, the same thing. That is a question of interpretation. Now, what law governs? We can look at some guidance from the UK, where the Sul America case in 2013 said that normally the law shows for the substantive contract will also apply to the arbitration agreement, but not necessarily. We look first at whether there's an express choice of law. If not, whether there's an implied choice of law, which is an interpretation question, and if not, what system has the closest and most real connection. Now, just this past spring in April, the Court of Appeals in the UK took Sul America one step further and said where there's an express choice of law in the main contract, it may amount to an express choice of law for the arbitration agreement. That's a matter of construction. But in all other cases, there's a strong presumption that the parties have impliedly chosen the curial law as the arbitration law. In other words, this brings us back to the place, the seat of arbitration. That language may not only choose the arbitration law, it may choose the law that applies for purposes of interpretation, the contract law of the arbitration agreement. There is the possibility of choosing what are called rules of law, rules that come from outside sovereign legal systems. IBA rules and guidelines can be particularly important. You need to be aware of them and think about whether you include them in your clause. ICC rules, Incoterms, Uniform Customs of Practice are examples. Now, rules of law, I think, is a confusing misnomer because it uses the term law. And if law requires a sovereign, then rules of law must require a sovereign, but that's not the language that is written in this process. So to summarize, 2 basic doctrines: separability, competence, 5 basic issues: consent, existence, formal validity, substantive validity, scope, and exclusivity. You want to look at your arbitration clause, ask as to each of those, what law governs, who decides the issue. The best rule in drafting is to be explicit and know that the first rule of private international law is that party choice of law is generally respected, so choose the law. Thank you. I think I've gone a little bit beyond my time. I hope not too far. I will stop there and turn it over to Raj.
You are muted, Raj.
Thank you, Professor, for such an insight into the law of arbitration that you've given to all the participants and also to me, as I've also learned a lot in this. I thank Center for International Legal Education, University of Pittsburgh School of Law, and ICFI Law School for inviting me for this session. Thank you for having me here today. What I'm going to do today is just a second, I'll put my slides on. Yeah, so what I'm going to do today is, Professor has given you a great insight and detail into the legal aspects of the drafting of arbitration law, the international arbitration law, whereas what I will do is I'll probably give you a practitioner's view to it. The key insights on drafting of arbitration clauses is something that I will be taking you on. So, in the next around half an hour to 40 minutes, I will attempt to take you through the important and critical things that we need to keep in mind during the drafting of arbitration clauses, because as we've seen, arbitration clauses generally are treated as the least important clauses and is normally, as a practice, copy-pasted from a previous draft and used as a boilerplate clauses. I think probably that's one of the reasons why the arbitration clause has been given a name of a midnight clause or a champagne clause. So what I intend to do over the next 40 minutes is to probably emphasize the need of a good arbitration clause and why we need to put in a far more importance to the clause. The clause requires its due recognition and we need to spend a little more time on it. It's extremely important, especially if you're dealing with cross-border disputes. A lot of important elements need to be taken into consideration on the enforceability issue, the seat, and like. I will take you through each one of them. One other important thing that I've also noticed, it's very important to probably cater an arbitration clause to your specific needs. It need not be one size fit all. It needs to be catered to each one's requirement. So therefore, it's very important to consider your transaction, consider where your parties are located, and then structure your arbitration clause. It is extremely important that you keep that in mind. If you are adopting, say, for instance, any of the institutional arbitration, then it is also important and equally important to ensure that you have looked at the model clauses of those institutions, and wherever required, please fine-tune those clauses to fit your requirements. It's not necessary that just because institution clauses are there, they may automatically be made applicable to you. You may need to tweak it to customize to your requirement. Having said that, I will just take you from here. So what are the elements of the clauses, the arbitration clause? The key elements according to a practitioner that you need to keep in mind as an arbitration clause is it should very clearly provide what the exclusions you want in your arbitration clause. What kind of disputes you want to get it adjudicated through arbitration, and which are the disputes which you don't want to include in your arbitration clause. So therefore, if you are looking to carve out a certain disputes from your arbitration clauses, you need to make the specific carve out and bring that exclusion into your arbitration agreement, so it's clear from day one. Second is sometimes considering the local jurisdiction. Let's say, for instance, in India, whether you want an interim relief provision to be provided for in your agreement. So therefore, if you want an interim relief, you need to provide for it in your arbitration clause. That you are excluding section 9, 27, and 37 from your arbitration. That means you will not be entitled to an interim relief. Otherwise, in India, the automatic provision is that interim reliefs will be applicable in arbitrations which are even seated outside India in an international arbitration, international arbitrations. So that's one of the clear exclusions that you need to provide for. You need to provide for number of arbitrators, the mechanism for appointment of arbitrators. Is it going to be an ad hoc arbitration? Is it going to be an institutional arbitration? Because your appointment mechanism may vary from ad hoc arbitration to institutional arbitration. So therefore, it's very, very important to also decide at the time of drafting of the arbitration clause that would you prefer an institutional arbitration or an ad hoc arbitration. It's also important to keep in mind seat of arbitration, what will be the seat of arbitration, whether seat will be in India, whether the seat will be outside India. If the seat is going to be in different countries, you need to also keep in mind, as the professor said, that the seat is at a place which is a signatory to the New York Convention or the Geneva Convention. Because at the end of the day, you want to ensure that if you have an award seated in a particular country, that award is enforceable. You don't want an award which is just going to be on paper, and you may find difficulty in enforcing those awards. So therefore, it's extremely critical that you choose a seat which is a signatory to the New York Convention, and where you want to enforce that award, even that country is a signatory to the New York Convention, because you don't want a situation where that you have an award and you want to enforce it in a country and that country is also not a signatory to the New York Convention. Then you may have even more difficulties. So therefore, keep that in mind while drafting of the arbitration clause, so that you know where your client is, where the counterparty is likely to be, where the assets of the counterparty are likely to be. The next would be the curial law. That's the rule of procedures, institutional rules. In the event where the arbitration is seated, you will have to apply the procedural and local law of that country. So you need to keep that in mind. You need to also accordingly choose the rules of institution, the law governing the contract, which the professor has very nicely elaborated as to what will be the law governing the contract, because it's extremely important that there's a clarity on what law will govern the contract. It's also important to ensure the language of arbitration, because in some countries you may find that while the language of arbitration may be good to be English, but at the end of the day, if there is an award, some countries may have a requirement to have that award translated in the local language. So therefore, it is equally important, the language of arbitration to be specified. As I said, choosing institutional or ad hoc, I think the world is moving towards institutional arbitration. Using of the model clauses from the institution is extremely advantageous, and it's recommended. because that makes things simple, because people who have framed it rules and who have framed those clauses are well experienced. They know what is required in a clause, and they've kept all of that in mind while drafting those clauses. Use simple language, clear and unambiguous language, because sometimes complicated language used in an arbitration clause could lead to dispute on what the language meant. And you don't want to start, as I said in my first slide, to start with a dispute on your arbitration clause. So it's very simple language. Use clear and unambiguous language. Keep your scope as wide as possible. Scope and ambit of the clause should be kept as wide as possible, so that you are able to bring in all disputes that you want to bring in into the arbitration. Clarify on what the seat would be. Proper law of contract, that's your governing law. Then the law governing the arbitration agreement and the actuarial law to be specified. Ensure all key elements are clearly specified. It is also important that parties preferably choose a member state of New York or Geneva Convention as the seat of arbitration for ease of enforcement, and reciprocity should be considered, because it's not only sufficient that a party is a signatory to the New York Convention or a Geneva Convention, but also where the award is going to be enforced, and that should also be a signatory to the New York and Geneva Convention, and ought to have ratified the New York Convention by way of a treaty. So it is also important that the country where you are enforcing it has also ratified New York Convention as a reciprocating country for enforcement of the foreign award. So if your contract has a multi-parties or multiple contracts are part of a transaction, plan for a possible multi-party arbitration. In today's day and age when there are complex cross-border disputes where multiple parties are involved in a transaction, we've seen these are regular features. So it's very important to have multiple parties, multiple contracts, so therefore to provide for a multi-party arbitrations. Always keep in mind not to confuse between seat and place and venue. As far as possible, use the word seat in your clause, because that takes away all the arguments about whether it was meant to be the juridical seat of the arbitration, whether your challenges will go to the court where the seat was, or whether it will go to some other court. That is very, very important to make seat as a key center of your clause and ensure that you're clarifying what the seat of the arbitration is. So you can use the language such as the seat of arbitration will be a particular seat, because that gives clarity, rather than keeping it ambiguous to say seat of arbitration will be say Mumbai or Delhi. That kind of gives no clarity. It's either or. So we don't want that kind of a situation. You want to be clear in what you want to have. So it's important that you say that the seat of arbitration is a particular place. Do not use a seat and venue interchangeably. It can create more complications. Specify venue separately if you have to, because there can be a situation where for certain reasons some arbitrators are not able to travel, or for certain reason the party is not able to travel, and a hearing is shifted to a particular city, but that would be a venue for that particular hearing, and it's not necessarily a seat of arbitration. The seat of arbitration is where your challenges to the petition would lie, and therefore you have to make it very clear which is the seat, and if you want a different venue, please clarify that there's a different venue. Also keep in mind a couple of other things as to when you choose a seat of arbitration in an international commercial arbitration, you must keep in mind what are the requirements of the local laws of a particular country. We've seen in the past that sometimes the local requirements of a particular country may be very different from what may be the local requirement in your country, and you have no clue of what it is. So if you're seating an arbitration in a particular country, I suggest consider looking up the Arbitration Act of that country, or generally checking on what are the rules that are applicable to that country for arbitration. Because we've seen situations where a country has a time limit to complete an arbitration within a period of 6 months, which may not be the case in your country, so you may not be aware of. Or there could be a particular requirement in relation to a particular country. Like for instance, some countries require an arbitrator to come physically remain present in a particular country to sign an arbitration award, arbitral award, whereas some countries don't require that. Some country may permit an arbitrator to sign an award from wherever he is. So it's very important to know what are the local requirements, local laws on arbitration. And the other that I would say is that also some of the countries also require a ratification of an award. So if, say, for instance, an award has been passed in Dubai, now Dubai requires a ratification of the award by the local courts. Now that is a very specific requirement for Dubai. It may not be there in other jurisdictions. So therefore you need to keep that in mind, that a ratification is required before an award can be enforced in another jurisdiction. And that is again something that we need to specifically understand before you put in your arbitration clause. As I already stated earlier, whether or not to exclude the applicability of interim relief provisions in a particular country which are available, like for instance in India, whether you want to exclude interim relief provisions or not is something that you need to decide, because depending upon who your client is, where is he located, what is his interest, you need to consider that, because tomorrow in one matter you may want to exclude it, in one matter you may not want to exclude it. So you need to be very, very carefully considering the fact that whether you need to exclude it or you don't need to exclude it. When you appoint an arbitrator, you also have an option sometimes to consider whether you want to appoint a particular expert in the field, to a field of, say, the manner in which the matter is. Say for an infrastructure dispute, you may want to consider engaging an engineer. Say for any other dispute, you may need some other technical expert. So you have an option to have an expert appointed as an arbitrator. However, as far as possible, avoid putting qualifications for expert in your arbitration clause, because sometimes we've seen that it's very difficult to find an arbitrator with a specified qualifications that are required. You may find an engineer, but you may not find an engineer with a specific requirement of qualifications that you may have specifically provided for in your arbitration clause. So you may leave it to say that an engineer may be required for this arbitration, but don't go ahead and specify what the qualifications would be. The practical experience that we've seen is in some arbitration, it works very well. In some arbitrations, it's better to have a lawyer or a retired judge act as an arbitrator. I've already mentioned the language of arbitration should be specified. Seat venue place. Now there's a lot of confusion always between this. What is a seat? What is a venue? What is a place? It's also a confusion for arbitration. What is a seat, venue, and place? And for civil suit, what is the seat, venue, and place? The courts, there is a different way to find out where the jurisdiction of a court would be, which court would have jurisdiction. For the purposes of arbitration, it's an agreement between the parties. In the arbitration clause, you would have provided for a seat of arbitration, which is your juridical seat for arbitration. That's where you would give that court of that city the right where to administer the arbitration, and if the challenge is there to an award, it has to go to that particular city. So therefore, it is very important to put which seat, what will be the seat of arbitration. as it gives a complete administrative power of that court in that jurisdiction to supervise your arbitration, including your interim reliefs, including your challenges, including the appeal to the challenges. So all of that will fall in that court. So it's very, very clear that you specify what the juridical seat of the arbitration is. The judgment of BGS Soma only reaffirms that position, which is a recent Supreme Court judgment on this issue, Supreme Court of India, and it clarifies the issue that the seat of arbitration is the focal point, and that should be very clearly mentioned in your arbitration clause. When you can be different, when you can have a venue which is different from your seat, but at the end of the day, when an award is finally signed, it has to be from the seat, so that any challenge to that award will be to the seat to the courts where the seat is located. Seat also governs all the interventions related to interim reliefs, appointment of arbitrator, and so on. You also need to keep in mind which are the disputes which can be arbitrated and which cannot be arbitrated, and what are not arbitrable. There are certain disputes which are specific and which are not arbitrable. Say, for instance, the rights in rem are not arbitrable. You cannot arbitrate a criminal matter. In a criminal matter, you cannot arbitrate on infringement matters, infringement of trademark, copyrights, patents. You can't arbitrate those disputes. You may be able to arbitrate the damages that may arise from these matters you may be able to take those disputes into arbitration, but infringements related claims, especially infringement injunctions, are governed by a specific statute, and you need to go to courts to get those injunctions. Insolvency matters are not arbitrable, and therefore you need to go to the insolvency courts. Matrimonial disputes can't be arbitrated upon. Operation mismanagement matters related to operation and mismanagement, which may be arising out of your articles of association, cannot be arbitrated upon. But if it's arising out of a contractual relationship, you may be in a position to arbitrate those. Role of institution in arbitrations. Curial law, rule of procedure. The institution helps you with the procedural law. It helps you with appointment of arbitrators. It has, most of the institutions have a very highly recommended panel of arbitrators, good practitioners in the jurisdiction with a lot of experience, and they are able to provide you with a good list of arbitrators from where you can choose an arbitrator. So it's important that you have institutional arbitration as far as possible. It helps you in administering the dispute. It streamlines the process. Your timelines are kept in check. It coordinates between the arbitrators. It helps you a lot of back-end activities, including ensuring that the fees are paid in time, collecting deposits from the parties. So all that additional work that you need to do otherwise in an ad hoc arbitration is taken care of by the institutions. I think institutions, in my view, have a far more advantage. Effectively, it also supervises and controls the entire mechanism of arbitrations. You will have some idea as to the cost involved, because most of the institutions provide as to how they compute cost of arbitration. There are mechanisms. Some of them have the calculators in place which you need to follow. So therefore, it's important. Institution monitors the timeline of the arbitrations very effectively. So you will normally see a shorter timeline when it's an institutional arbitration. And it also takes care of a lot of issues related to service of documents and all of that. You just need to send it to the institution, who will then take care of servicing of documents to the counterparties, all of that. When you choose an institution, and how do you choose an institution? So it's also very important, the nature of dispute that you are referring to an arbitration. If it's a small value, small dispute, it may not be worth going for an institutional arbitration if it's a very, very small dispute, and it may you may want to consider an ad hoc arbitration. However, if it's a big, large, complex dispute, then you may want to consider going for institutional arbitrations for a couple of reasons. One, it would provide you with emergency arbitration provisions. It may also provide for multi-party references, consolidation of arbitrations. It has simpler filing procedures, and these clauses can effectively be implemented. So if the rules provide for all of these, you may want to consider this, keeping in mind the number of parties that you may have in your arbitration and how complex it is. Also, for enforcement, it becomes easier because institutions, also some of the institutions also, before the award is passed, ensure there is a quality check and a check in relation to the compliance requirement of each country, and that they have reviewed the award, keeping in mind that the award may be enforced in a particular country. So the local requirements of each country is taken care of. Say, for instance, a small requirement to pay stamp duty for an award in India, that award needs to be on a stamp paper. Now, if that is not done, then you may have an excellent award, but it becomes unenforceable if it is not stamped. So therefore, the institutions take care of that, and it is very, very important to do that. Second, some of the institutions also provide this emergency arbitration facilities, where they can appoint an emergency arbitrator. The only thing especially for India, is to enforcement of the emergency arbitration. We've seen in many cases that after emergency arbitrations take place and emergency awards are passed, you are required to go to court and file another application in the Section 9 to get additional interim reliefs so that they become enforceable in India. So that's very, very important to keep in mind. As I already mentioned, you need to be very conscious about the fact of your dispute, whether it's a large dispute or a small dispute. Depending upon that, choose the arbitration, ad hoc or institutional. I will quickly take you through some of the asymmetrical arbitration clauses that we've seen in India and how the courts have reacted to it. So the first case of the India Infoline Finance Limited, you may just want to quickly go through this clause. This was a case in the Delhi High Court, and Delhi High Court rejected this clause on the ground that because of the underlined portion, it says that all arbitration proceedings shall take place in Delhi or such place as may be decided by the lender in its sole discretion. Now, this did not identify a seat of arbitration, and the Delhi High Court felt that this does not give an indication that the parties had agreed that the seat of arbitration was Delhi, and therefore rejected this application in court and rejected the clause itself and relegated parties back to file proceedings in a different court. In the second judgment of Jagdish Chandra versus Ramesh Chandra, this is a judgment of the Supreme Court of India, and where if you would see the underlying portions, it says, let's read the whole thing. If during the continuance of the partnership or at any time afterwards, any dispute touching the partnership arises between the partners, the same shall be mutually decided by the partners or shall be referred for arbitration if the parties so determine. Now, there was no finality on or the intention. The intention of parties were there, but the finality was not there as to when the matter, whether the parties have to, this dispute has to be referred to arbitration or not, because it was kept open whether it should, when the parties determine it, and the court said this is no finality here, and therefore we can't consider this as a valid arbitration clause, and rejected this clause. The next one was the Systems for International Agencies versus the Rahul Coach Builders Private Limited. And this was a peculiar case where if you see the underlying portion, it says arbitration under the bylaws of Indian Companies Act 1956, and all amendments of this act up to the date or shall be settled and decided by arbitration as per international trade laws and all amendments of this act up to date. Now, there is no such arbitration as per the international trade laws in India, and there is nothing like arbitration under bylaws of Indian Companies Act 1956. So clearly there was a mismatch as to how this arbitration is going to take place, and the court rejected this clause itself. So therefore it is important that when you are drafting an arbitration clause, it is all encompassing clause. And if you are interested, you should consider reading the judgments of Enercon Limited versus Enercon versus Enercon and Bureau Flaguera, which provides as to what an all-encompassing clause would entail and what all will it cover. But there are also certain restrictive clauses which you will be able to find in the judgment of Bharat Sanchar Nigam Limited and Motorola. The third kind of clauses are restrictive and conditional clauses. These are open for interpretation, and therefore you have to be very careful what you are looking at. I will take you, I'll probably take you through what all encompassing clauses are, restrictive clauses are, and what are some of these clauses. So what will you have in an all encompassing clause? So all dispute, controversies, or differences in respect of this agreement for which an amicable settlement has not been arrived at by the parties within 30 days, including the validity, interpretation, construction, performance, and enforcement or alleged breach of this agreement. Now you would see that the nature of disputes that are covered here are very wide and all encompassing. Therefore, this is an inclusive clause. All encompassing clause. The parties shall refer the same to sole arbitration tribunal to consist of 3 arbitrators, of whom 1 will be appointed by each of the party, and the arbitrators appointed by the party shall appoint the third presiding arbitrator. So again, this covers as to the appointment mechanism. Again, provides who will appoint and how the arbitrators will be appointed. So again, it encompasses the whole issue. The next one is in relation to which will be the institution governing it. So it also provides, you can also provide that in your clause as to which institution will govern the arbitration. The arbitration will be governed by the rules of which institution and who will be the supervising institution. It needs to also provide for where the seat of the arbitration is. If it is in India, you will have to say, and you may want to say the arbitration will be under the Arbitration Conciliation Act 1996. You may also want to provide for jurisdiction of the courts if it's in India and where the seat is located. Now, some of the restrictive clauses you would see is like, in the event of any question, dispute, or differences arising under this agreement or in connection therewith, into bracket, except as to the matter, the decision to which is specifically provided under this agreement, the same shall be referred to sole arbitrator. Now, here you would see they have specifically given a restriction which is provided for in the bracket. Now, the moment you put these restrictions, they are all open for interpretation, and there could be a dispute on this itself. So as far as possible, avoid such restrictive arbitration clauses because these can lead to a long drawn arbitrations, even on this point itself. So avoid these kind of restrictive arbitration clauses. Now, this is a very peculiar kind of a clause. So this is a clause which has been considered by 2 different courts in 2 different manners. Same clause considered differently in 2 different judgments. So this was a clause: if any dispute or difference shall arise as to the quantum to be paid under this policy, the liability being otherwise admitted, such differences shall be independently of all other questions be referred to the decision of the sole arbitrator to be appointed in writing by the parties to, or they cannot agree upon a single arbitrator within 30 days of any party invoking the arbitration, the same should be referred to a panel of 3 arbitrators comprising of 2 arbitrators, one to be appointed by each of the parties to the dispute and differences, and a third arbitrator to be appointed by such 2 arbitrators, and the arbitration shall be conducted under and in accordance with the provisions of Arbitration Conciliation 1996. It is clearly agreed and understood that no dispute or difference shall be referable to arbitration as herein before provided if the company has disputed or not accepted the liability and under or in respect of this policy. Now, if you see the next point, that is the United India Insurance Company's judgment, you will see how the Supreme Court dealt with this issue. The complete denial of paying an insurance claim does not meet the condition precedent for initiation of the arbitration, and no arbitration proceeding can be initiated against the insurer for payment of an amount under the insurance policy. Now, under the similar clause, how the Delhi High Court dealt with this issue. Partial payment of claim under the insurance policy amounts to admission of liability, and dispute as to the quantum of the amount payable under the insurance claim by the insurer to the insured are to be adjusted through arbitration. So one holds that it is arbitrable, one holds it's not arbitrable. From the same clause, we can have different kinds of decisions coming out. So it's important that how much you want to put conditions and restrictiveness in your clauses. The other important point that I see is very important to keep in mind when you're drafting clauses where you are looking at complex arbitrations. So multi-party arbitrations, it's extremely important to be very, very careful while doing that. Typically 2 possible scenarios, multiple parties to the same contract. That's consortium contracts, shareholders agreements, and like. And the second is multiple contracts with different parties, which you will see very common in banking and financing documents. Potential issues, you have incongruous dispute resolution clauses in multiple contracts where you will see there are 3 different contracts. All 3, if you want to club them together, you are not able to club them together because you've chosen 3 different institutions in all 3 contracts. So you can't merge, you can't consolidate arbitration, and that may create a problem for you. Very typical issue that we've seen. Joinder of parties to the arbitration once the tribunal has been constituted. It also has an issue if you have not made them parties from the beginning. Joining a party to an arbitration where they are not parties to the arbitration agreement can also create an issue. As regards in a multi-party arbitration, you need to keep in mind the clarity of appointment, who will appoint, invocation procedure. We've seen that sometimes you have, in a shareholders disputes, you may have promoters on one side, investors on one side. And there may be 5 promoters together, 3 investors together. So you may have clear sets as to who can invoke or who will appoint. So you can have all promoters appointing an arbitrator together, all investors appointing arbitrator together. So you may have sides or camps, as you may call it, who will appoint an arbitrator. Sometimes you may also have a situation where you will find in an agreement that all investors may not have an issue with the promoters. There may be one set of investors who may have issues with the promoters. Then when you're drafting that clause, you need to keep that in mind, that you're providing language such as such dispute between such parties, so that it takes care of only those parties who are affected by the transaction can invoke arbitration. And that's very, very important to ensure that the language of the arbitration is drafted carefully. Sometimes you also see in case of multiple contracts, there are umbrella arbitration agreements, which is referred in each contracts for the stamp duty benefits that they take. In such a scenario, you need to take care that your arbitration clause in each agreement are identical or quite similar. So that at least you have, say if you're having a sole arbitrator in one agreement and a 3-member tribunal in the other one, you may have a problem. You may want to ensure that you have a sole arbitrator in one or and sole arbitrator in all, or you may have 3-member tribunal in all. So it becomes easier. You may have chosen an institution, then choose institution carefully, and then ensure that you have the same institution in all your arbitration clauses. When it's a series of contracts, a series of transactions, it's very important to do that very carefully. Again, choose the right arbitral institution. Is extremely important. That which arbitral institution provides for consolidation, which arbitration tribunal also provides for appointment, composite references. It's extremely important that you have chosen an institution which provides for multi-party arbitration and consolidation. Different institutions provide for different institutions and different rules. The joinder of parties, ICC has under Article 7, SIIC under Rule 7, LCI under 22.1, all provide for joinder of additional parties. After invocation of arbitration by consent, for all parties, and if addition is prima facie bound, again for appointment of tribunal, all of them provide. So all institutional rules you need to be very carefully looking at what provides for what provisions, which rules provide for consolidation, which rules provide for appointment of the tribunal, whether they allow composite reference, joinder of parties. All of that is extremely important. Therefore, it's important that you go through the rules very, very carefully. What I will now do is briefly take you through some of the model clauses. For an ad hoc arbitration, you may want to just go through this clause briefly. This is more keeping in mind the Indian scenario and the Indian law, which I have created here. It says that in the event of any question, differences, or dispute arising under or in connection with this agreement, include any question regarding its existence, validity, or termination, then such dispute shall be settled finally and exclusively by the arbitration under and in accordance with the Indian Arbitration Conciliation Act 1986 or any statutory modification or reenactment thereof. The parties shall mutually agree to appoint of a sole arbitrator to determine the dispute. In the event of the parties failing to agree within a period of 30 days, each party shall appoint one arbitrator, and 2 arbitrators so appointed shall jointly appoint a 3rd arbitrator. The seat of arbitration shall be whatever you choose. The language of the arbitration will be, again, whatever you choose. This, you will see, it's an all-encompassing clause, includes all kinds of disputes and differences existing of validity, interpretation of the contract. So we try to make this clause as broad as possible, as inclusive as possible. We've also now, because the present Arbitration Act in India also provides for a fast track arbitration, we've tried to draft a specific clause for a fast track arbitration. What I can do is I can probably share the draft model clauses with you after the presentation is over, and I can probably drop that in the chat box or share it with the organizers who can share the same with you. This is specifically a clause on Mumbai Center of International Arbitration. I have taken the model clause from there. Of course, if you want to use this clause, you need to tweak it to your requirement. Similarly, for ICC clause, I have picked up the model clause, and you may choose to modify it as you need it. Same for the LCIA, SIAC. These are some of the major institutions that we come across, and we come across them regularly. We see a lot of disputes being referred to these institutions, a lot of arbitration coming to us from these institutions. So that's why we picked up these specific clauses. Thank you. Thank you. Rishabh, over to you.
Thank you, Raj, so much again for such an enriching session. I think the whole the drawback, the connection you draw on to the Indian context and the US context was really, really wonderful. And same on the lines, Professor Brand. Thank you again. I know I had so many opportunities of listening to you personally on arbitration law, being attending during the arbitration class at UPET. It was a pleasure hearing you back then, and it's been pleasure hearing you right now today. Moving on, I would like to invite Anvesha Paniguri, Assistant Professor, ICFI Law School, Hyderabad, for the Q&A round. Anvesha, it's over to you right now.
Okay, hello everyone. Now we'll be moving on to the most enlightening and most interesting part of the event. So I will be directing questions towards Professor Brand and Mr. Panchmatia separately for the first few this thing, and you can, of course, you may answer the other's question if you have insights to give. So my first question will be to Professor Brand, and it's a very basic question asked by one of our attendees. As to what is the difference between the seat of arbitration and substantive law selection?
You're right. That's a basic question. It's a very important question.
Yeah.
You should, and as you see from the UK cases I cited, there has been a good deal of confusion in that. There's an assumption that there are two basic choice of law clauses in an arbitration agreement. One is the choice of the substantive law to be applied. That's the contract law to be applied to the commercial transaction. The other is the choice of the arbitration law, the lex arbitrii, the curial law, and that, as both Raj and I have pointed out, that is a law that is chosen by choosing the seat, the place of arbitration. When you say the seat of arbitration shall be New York, that means that you are choosing the arbitration law, the procedural law. Now, that leaves open the question of what is the law governing the arbitration agreement itself, okay? And in the UK, the courts have taken the position that they've moved from the position that there's kind of an assumption that the substantive law of the contract is the substantive law for the arbitration agreement. And they've moved most recently this year in the Chubb case to the position that the curial law, that if there's nothing expressed, then the curial law will be the substantive law of the arbitration agreement. Okay, but the curial law is normally the lex arbitrii, the arbitration law. To me, this is why there needs to be an adjustment to everybody's drafting of an arbitration clause. And so you need to make sure you have three clear express choice of law clauses in your contract. One is the substantive law governing the contract. One is the arbitration law, the curial law, the lex arbitrii, which you get to through the decision on the seat, the place of arbitration. And the third is the law governing the arbitration agreement. Okay, and I think given the way courts have been dealing with this, and given the way a whole lot of time and energy and cost has been expended on litigating it, it really is important now to put in that third clause to say expressly the arbitration agreement. If you want it to be the same as the law governing the rest of the contract, say the law governing this contract, including the arbitration agreement, shall be the law of X. Raj, your thoughts on that?
No, I think I completely agree with Professor Brand on this, and I think it's exactly the points that he's making is very, very important right
Okay. So the next question is actually from me. Professor Brand, you said that right now it is recognized that any recording of in any form will amount to an arbitration agreement being in the written format as per the New York Convention, according to the amendment, right? So my question is, if the agreement between two parties is oral but is recorded, will it be considered as an agreement in writing, or is it recorded in the written form? If I'm making any sense.
Yeah. So if I simplify that question, it is, how do you satisfy the requirements of Article 2 of the New York Convention that you have an agreement in writing? And if you are the draftsperson, you make it explicit. You don't raise any questions. You don't allow for any distinctions. Okay. You have it in writing, signed by the parties, clearly done. Okay. Now, what if you have an exchange of emails? What if you have a click wrap agreement? Okay. Is that in writing, signed by the parties? Now, option 1 of the 2006 amendments to the UNCITRAL model law does allow you to satisfy the Article 2 requirement of the New York Convention, or at least it suggests under national law that you can satisfy the treaty rule that way. There are commentators who dispute whether simply putting that into your national law will give you that result. And the option 2 is the position that would go with those commentators and would not adjust national law. Now, UNCITRAL also has a law on instruments on electronic signatures. Okay. And if the law says an electronic signature is a signing, then you look to the applicable law. So what you do is, if you don't put it in writing and make it explicit, signed by the parties, you have opened yourself up to a series of private international law questions, of conflict of laws questions. You should not do that if you're the draftsperson. If you're the litigator and you're dealing with language where the draftsperson was not that careful, okay, then you can face that question. If you're in a state that has adopted option 1 under the UNCITRAL model law, you make that argument, but the other side's going to make the argument that says, wait a minute, there's a treaty requirement here. You cannot, by national law, amend the treaty. And that's the problem here. For 164 treaty parties to go in and amend the New York Convention on that issue is incredibly difficult. That means for the draftsperson, simply be careful, do it right at the outset.
Okay, and the next question is, what is the effect of an arbitration clause added by an employer in an employment contract, which is void ab initio because of undue influence? Does the fiduciary relationship come into question?
Well, I'll take the first shot at that one again. The answer is it depends. It depends on where you are. And this demonstrates how national law can serve to amend unilaterally a state's obligations under the New York Convention. For example, throughout Europe, as a result of the Brussels I regulation, you cannot have a binding pre-dispute settlement choice of court clause in an employment agreement. And through their directives and regulations and enactment of state law, national law on arbitration, you get the same result. You cannot have a binding pre-dispute arbitration agreement in an employment agreement. In the United States, those can be binding. Okay, now you ask, well, wait a minute, what about the consent requirement? In a way, it shows you each legal system is looking at that consent requirement in a different way. And the US Supreme Court has been very broad in its understanding of party autonomy for choosing an arbitration clause. It's taken an economic analysis on that in employment contracts, in consumer contracts, and basically said, look, the value to everyone of the employer or the merchant, knowing that all disputes will be settled in one place, is significant, and the consumer gets a better deal in consumer contracts because the price is reduced. The employee somehow gets a better deal. So whatever economics or analysis you take on that, you have to understand that national law differs on that. It depends. The answer to that question depends upon national law. It depends upon the way that national law, if it's an international matter, if it's an international employment relationship, it depends on the way that national law has, in effect, amended within that one party the effect of Article 2 of the New York Convention.
Okay. I would also like to answer Raj to answer this question with regard to the Indian context.
Yeah, so in relation to Indian context, the dispute that may be governed, say, by Industrial Disputes Act or Payment of Wages Act cannot be arbitrated upon. Therefore, they have to go and follow the requirement under those statutes. However, if it's a level contract, if it's a contract at a higher management, they may have an arbitration clause. And it's not necessary that all arbitration clauses are void ab initio, because both parties would have agreed to sign those arbitration clauses unless they are able to establish that this clause was made to be signed under some kind of a coercion or an undue influence, which is a very, very high threshold. It's one to say that there is a coercion or an undue influence, but it's other to establish that there was coercion or undue influence. So it depends completely on the fact situation. Generally, just because there is an arbitration clause in an employment contract of a managerial level position or a senior position does not make it unvalid.
Okay, so in the similar line of argument, there's also a question regarding standard form of contracts and the consent element therein, and with regard to the arbitrability of it. And it's a repeated question by a lot of our attendees with respect to standard form of contracts.
Is it for me?
Yeah, it's both of you can have a take on it.
Take the first shot, Raj.
Yeah.
So standard form of contracts provide for arbitration clauses. Now, many courts have taken a view that there is a standard form of contract, and as long as it was disclosed to the parties that there is a standard form of contract, and at the time of executing this contract, they have not taken any objection of the same. And as long as they are fair and proper, and parties have equal opportunity to appoint arbitrators, there is no problem. But if there are unilateral appointment provisions in the standard form of contract, then they fall foul of the requirements of the local laws. Like under the Indian Arbitration Act, now you have Schedule 5 and 7. So if you reach, or if that clause in foul of Schedule 5 or 7, then there is a problem with that clause. And that will have to be, then you'll have to go to court to appoint for appointment of an arbitrator or amend that arbitration clause.
Okay. And Mr. Brand?
Yeah, well, generally, once again, national law and the European example is to carve out employment contracts, consumer contracts, and insurance contracts and create special rules for them and make, and in a sense, make it all prohibitive that you cannot have a pre-dispute binding choice of court or arbitration clause. Now, in the standard international commercial contract, if you take, for example, sale of goods contracts, the seller will have a set of standard terms and conditions, and when they send their purchase offer, they will say this is governed by our standard terms and conditions. And the buyer will then, when it sends a correspondence back, say, yes, we're going to do this, and it's governed by our standard terms and conditions. So the first question is a contract formation question, and so it is, which set of standard terms and conditions is in the contract, if either, in that case, and that depends not on the law of arbitration, it depends on contract formation law. And whether you have a last shot doctrine, a knockout test, whatever, for contract formation. And so the first step, and you have to, again, go to rules of conflict of laws. This is why conflicts is always important. Conflict of laws to determine whose law governs the question. Okay, and under that law, then whose standard terms and conditions govern. Now, if you have a dominant seller and a buyer who really has no choice in the matter, and the seller says, here's what it's take it or leave it, you take our standard terms and conditions or else, please let us know if you accept, right? And the buyer then says, well, I want a quantity of 10. And under most laws, you'd have acceptance of the standard terms and conditions, but then do you come up with the question of, do you really have consent to the arbitration agreement? And you first apply the separability doctrine that says, well, you look at the arbitration agreement separate from the rest of the contract. So, but you may apply the same contract formation rules to the two, and in most cases, you probably will. But it boils down to a question of contract formation, so the first part is consent. Whose law applies to contract formation? What is the rule? How is it applied here? The second part then, though, does go to substantive validity, because if you have, even under the law that you determine is applicable for contract formation, if you have mandatory rules that prohibit this type of contract, make it non-arbitrable, or you have rules that say this type of a party cannot enter into an arbitration agreement, that it is void, you then fall under the New York Convention into paragraph 1 or paragraph 3 under the arbitrability exception or the validity exception, and you have a substantive validity question. Once again, you have to look at the conflicts rules, whose law of substantive validity applies, how does it apply here?
Okay. Thank you, Professor Brand and Panchmatia. The next question is with regard to arbitrability of competition law disputes. Now, the question is to both the parties, but it is basically asked in the Indian context that the Indian courts have denied the arbitrability of competition law disputes time and again, but some other jurisdictions have happily accepted it. So what is your stand on it, and what is your stand on extending the Indian arbitration law to govern the competition law disputes?
See, the courts in India have taken a very clear view so far that the competition disputes have not been entertained so far. So that would be for me to speculate whether, how and what the courts would do. Because there is also a competition commission, and competition commission looks after a lot of disputes that arise out of the Competition Act. I think most of the disputes are going there. Maybe if there is some dispute which may relate to a contractual dispute, where it's only a nature, claims are in the nature of damages, that may be referred to arbitration.
Okay. Professor Brand, do you have a take on it?
Well, in the United States, this is an issue that was settled very clearly in the 1970s in a Mitsubishi case, where the Supreme Court was faced with the question of whether a Puerto Rican automobile dealer had to comply with an arbitration clause in a Chrysler Mitsubishi contract and be forced to go to Japan to arbitrate all issues, including antitrust issues. And the court said yes, that first question was a matter of scope. and it was a broad scope arbitration clause. Broad scope includes questions of arbitration. The second question was the question of arbitrability. And at that point in time, there were real questions in the lower courts about arbitrability of arbitrability of public law issues, which included things like antitrust law, securities law, what we call our RICO, corrupt organizations law. And the Supreme Court said, no, if you agree to go to arbitration, it's a broad arbitration clause, you go to arbitration. But what they said was that in effect, they were looking at the New York Convention, and they were saying that in Article 2 of the New York Convention, the grounds for avoiding going to arbitration are much more limited than the Article 5 grounds for refusing recognition and enforcement of the arbitral award. And the Article 5 grounds include public policy. The Article 2 grounds do not. So they were careful to point out that, look, even if you go to Japan and have 3 Japanese arbitrators who must apply US antitrust law if you raise it, if they get it wrong and they get it wrong enough that it violates our public policy in the United States, then it won't be capable of being recognized and enforced.
Thank you so much once again. The next question is with regard to enforceability of arbitration clause in an unstamped contract. So anyone who wants to take the question. Unstamped contract, a contract which is...
In the United States, we don't really have the concept of stamped and unstamped contracts, so here doesn't matter.
So the question goes to Raj then.
Yeah, so there is the problem in India for a document which is not stamped, because the courts have said that there can be impounded document which is required to be stamped, is not stamped, can be impounded at any point in time. So the moment you go to court for enforcement of that award, the court is likely to impound it, that award itself as well. It will also look at the primary agreement under which the arbitration had been invoked, and whether that was sufficiently stamped or not. And courts are now very clear in taking view that stamping is necessary, and therefore you have to consider stamping. It's important to have the stamping done.
Okay.
Of the requirement for a good award in India, and therefore all institutions take care of that the award is sufficiently stamped before it is handed over to parties, because in India, again, different states have different requirement of stamping.
Okay.
Say Maharashtra may have a particular requirement, and Delhi may have a different requirement, Bangalore may have a third requirement. So you need to be very, very careful as to where you are going to have that award enforced.
Okay. The next question is with regard to smart contracts. The particular attendee is asking that usually in most of the smart contracts, there's no opportunity for negotiations. So what is the take on enforceability of such smart contracts, and with regard to the consent element and arbitrability?
Go ahead, Roz, take the first shot.
Read the question.
Do you want? Well, I'll take a shot at that. The simple answer is that's a really new area of the law, and there are issues yet to be worked out on that. Now, you get back to the question of consent. How do you do that? If by smart contract, and my understanding is it can be different things to different people, but if by smart contract, what you basically mean is contracts that are computer generated. The buyer, when its inventory gets low, its computers will automatically place an order with the seller, which will automatically then confirm by computer and ship so that the inventory is resupplied, and that those contracts then basically are generated by algorithms. How do you get to the question of consent? And certainly if it crosses borders and you're taking a New York Convention, do you have an arbitration agreement in writing signed by the parties. It would seem to me it depends upon the foundation for that smart contract. You're not going to have that relationship without some contractual arrangement at the beginning, which is generated by real people, not by algorithms. And if you're drafting properly, that's where you should put it in.
Okay.
You shouldn't have an algorithm that adds an arbitration clause, it seems to me.
Okay, okay. The next question is particular to Professor Brand, because, sir, you spoke about arbitration being non-governmental in nature in the beginning of the session. So Mr. Mahmood is asking that Iraq is still not a party to the arbitration system or any arbitration, international arbitration centers. So how do you reconcile between the non-governmentality of arbitration with regards to the government needing to recognize, and a particular government which needs to recognize and enforce the award?
Well, the simple answer, O'Day, is that I'm relying on you and your colleagues in Iraq who have graduated from Pitt Law to make sure that Iraq becomes a part of the international arbitration community, a party to the New York Convention, and adopts the UNCITRAL model law. That's the simple answer. The question, as I see it, does go more to mentality and development, and in countries that have, many countries that had an anti-arbitration bias, and Latin America is a good example, have moved into the arbitration community and very strongly are there. I hope that Iraq will get there. My understanding in Iraq, and this is important because in other countries that have not signed on yet, I think it's important too, because there is a question about what kinds of reservations and declarations you can make when you sign on to a treaty. And a number who have signed on to the New York Convention have signed on, make it with a declaration that it will operate prospectively only. I know there are problems where there is concern, where there's an outstanding arbitration award against a state, and concern that if that state then becomes a party to the New York Convention, that award becomes enforceable everywhere against them. So far, it appears that the international legal community has respected those declarations that are the state that the convention shall operate prospectively only.
Okay. Raj, do you have a take on it? Okay.
I think I agree with Professor on this.
Okay, so we'll move on to the next question.
Sorry, Anvesha, I'm contradicting.
think-
Right. Yeah, it's.
No,
I think
it's
it's
okay. I
almost.
think it's almost time.
Almost time, and I know we still have almost like 15 to 20 questions unanswered. So I think what I'm going to do is, most of the people have included their questions in the feedback form, so we'll take it from there. And if I cannot answer them personally, I will reach Professor Brand or I'll reach Raj to have a take on it. But again, I think Uday, first, thank you so much for joining. I'll give you a personal thank you. I think the whole purpose of, Professor Brand, I think he mentioned first to me, like the Middle East and also the Iraq, the arbitration influence on them is uprising because, the PIT law has such a good integration. And every year, PIT law, Professor Brand personally travels to the Middle East to train everyone in the Middle East law schools. And, it's such a beautiful thing to see uprising lawyers and the practitioners coming from there. So on that take, I think the arbitration has a very good influence in that manner. Maybe, and one thing I have been seeing, and maybe Professor Brand can answer this on my take, is I see a lot of young arbitrators now. So, whereas there was a time when arbitrators were to be, very experienced and, very profiled in their own manner. So what do you think? can the young arbitrators fulfill the same pledge as the experienced arbitrators do?
Yeah, Rishal, that's an important point. I think that international arbitration in particular used to be the province of a small group of old white men. That has changed dramatically. There is a group calls themselves Arbitral Women that's been made huge strides in seeing that women are better represented in the arbitration community. The diversity of arbitrators has increased. It's not where it should be by any means, but it is increasing. There is this conundrum. If you're representing the party and you want to appoint someone as arbitrator, you want somebody that has a track record. Okay, and you can check that track record as much as possible. That makes it hard to get in for the first time, but you get onto the lists of the various arbitral institutions, you become involved and begin to develop that reputation so you do it. It's a great area for young lawyers I hope that we will not be moving backwards in terms of global trade as a result of recent events. I hope that the global trade in the law and legal profession will be there as well. And with that, perhaps I can make a comment and wrap things up. I want to really thank our colleagues from ICFI at Hyderabad, Rishav, Raj, Anwesha, Rao. Everybody, this has been a great start to a partnership. I look forward to continuing to work with you. I would remind everybody that keep an eye on the website. We will post the PowerPoint slides on the CILE events webpage. Take a look at it. We'll also give notice there of the next partnership webinars, and perhaps we can begin planning another one with ICFI.
Perfect.
So, thank you, everyone, for joining us.
I'll conclude by adding few more statements. I think, the ICFI PIT MOU is just a setting milestone, and it's a very important thing to establish some global grounds. On that front, I'll personally thank Professor Avian Narasimha Rao, sir. Thank you so much for giving me such an administrative support and correcting me time to time. My colleagues, Anvesha, Dilip, Richa ma'am, everyone, thank you so much for correcting me and, adding some valuable inputs time to time. PIT family, Kim, Deb, Emily, Professor Brand, you personally, and Raj, thank you so much again, everyone, for making this possible today and having an enriching 2-hour session. So again, thank you, everyone. Thank you so much.
Thank you.
Great. Take care, everyone.
Thank you and goodbye.
Thank you.
Goodbye.